Hello and welcome to Moneylife. This is Sucheta Dalal. This week, I'm going to talk about a landmark order by the Supreme Court. If you're a home buyer, you will absolutely empathize with what has happened last week. On 29th April, the Supreme Court issued an order which directed the Central Bureau of Investigation to register not one or two, but 7 preliminary inquiries and to set up a special investigation team to probe what it called the unholy nexus between lenders and real estate developers. This probe spans many urban centers, which includes the entire national capital region, including Delhi, Mumbai, Kolkata, and Chandigarh, and hopefully many more. We've written about this order. What I'm doing today is discussing it. This order was delivered by Justice Suryakant and Justice N. Koteshwar Singh, and it's part of a broader assertiveness that we have seen in 1 week, because there was another significant ruling last week where the Supreme Court cancelled Jindal Steel's acquisition of Bhushan Steel under India's insolvency code. Now, this one also has a lot to do with the insolvency code, because the same lenders who are part of the unholy nexus also then go and take advantage of this insolvency code. Both orders taken together are bound to trigger regulatory reform, or at least we hope they're going to. This has to cover banking, real estate, as well as insolvency resolution. Now let's go back to 29th April. What did the court say? It said primarily that the focus will be on Supertech Limited, which is the same notorious Supertech whose 40-story twin towers in Noida were demolished in 9 seconds in a controlled explosion, and people across the country were watching it on live TV. This happened in 2022 after a decade-long legal battle by homeowners and others on all the illegalities. In fact, the order to raise the towers goes back to 2014 when the Allahabad High Court ordered a demolition, but it took until 2021 before this was ratified by the Supreme Court, and August 22 before it happened. In fact, what happened after the demolition is most interesting. Supertech declared bankruptcy soon after. This is a company which has 21 projects across 6 cities, financed by 19 financial institutions. So thousands and thousands of home buyers were affected. There was no justice. All that happened was a spectacle with zero deterrence. In fact, I wrote in 2022, and there's also a video blog, which says that this wildly expensive demolition, cost 500 crore, would not deter wrongdoers, since it did nothing at all to nail those who facilitated the brazen actions of the realty group in granting illegal permissions, financing the ongoing construction, and ignoring investor complaints. They just did not listen to home buyers' complaints, which would have fixed the issue long before the need for a demolition. I had also written, for far too long, bankers and lenders have gotten away with colluding with over-leveraged realty companies, breaking the rules. They've not only failed in their fiduciary duties, but they have ruthlessly tried to use the law to make scapegoats out of home buyers. As secured creditors, they are now heading the queue when an insolvency process starts, which means that apart from what they write off, they're winners all the way, and the complete losers are the home buyers. So why is it different this time? Because the Supreme Court is focused precisely on the unholy nexus between builders, lenders, and of course, government officials who facilitate this abuse of rules. The court also plans a court-monitored investigation, so hopefully people will be scared of doctoring it. So here's a quick summary of what this Supertech issue is about. Basically, the Supreme Court decided on 170 petitions involving 1,200 apartments, houses, whatever. The Supreme Court first provided relief to home buyers, saying recovery certificates against them, which were extracting EMIs from them, would be stopped. Now, what are these EMIs? These home buyers had fallen into a trap of subvention. The subvention scheme is what builders use to attract investors. What they tell them is, buy at the time of booking, sign an agreement with us. It's a tripartite agreement with the lender on one side, the builder on one side, the buyer on one side. No EMI will be paid by the home buyer until the property is delivered. Sounds very good, especially because under the Real Estate Regulation Act, they very strictly say that this is the date of delivery, these are the dates of completion, every slab that is put is documented and there in the agreement. What happens in reality is the opposite. The builder just stops paying after a few EMIs, does not pay the lender. The lender waits for a while. Sometimes the builder just declares bankruptcy. And then the tripartite agreement has a clause which says that if builder doesn't pay, they recover from the investor. So these home buyers, without even getting possession of their house, have to pay EMI with no sight of delivery. In fact, many large developers have failed to make payments and have gone bankrupt, especially after 2017-18. And lenders have begun to coerce home buyers. Many have ended up paying substantial amounts for projects that have not even been launched. Forget about completed. Some have not even started construction. And lenders have gone ahead and disbursed as much as 70 to 80% of the sanctioned loans to developers, completely in violation of milestone-based payments that they're supposed to make. Why do they do it? Because they know that home buyers are helpless unless something big happens and thousands of them get together and then slowly wind their way. They are helpless. These apartments are expensive. They have to fight. And that's why it's at least come to the stage where you have a Supreme Court looking at issues, getting started, making the scathing observation that Supertech alone had secured 5,000 crores since 1998 through such tripartite agreements from 19 financial institutions. Clearly, this smacks of collusion and violation of the RERA Act. Shouldn't the government be acting? No. Instead, real estate experts and advocates like Vinod Sampath, who practices in Mumbai, says that there is plenty of evidence of collusion between builders and bankers. It's common knowledge. And there are also plenty of examples of builders having stopped paying EMI within a few months of signing the tripartite deal. In fact, he's been warning buyers to be alert to this mischief and ensure that construction is proceeding as documented. And he suggests file a police complaint at the first sign of failure to comply with statutory obligations and don't fall for the sweet talk of builders. Will the Supreme Court order make a difference? Will it lead to action when a spectacular demolition made no difference? Personally, I think it does. First, because the Apex Court wants to monitor the investigation on a monthly basis. And when there are hearings in the Apex Court, they get reported nationwide. This means that there'll be accountability, there is seriousness, and there will be awareness. Secondly, in addition to forming an SIT, the Supreme Court directed the Secretary of the Ministry of Housing and Urban Affairs, as well as the Reserve Bank of India and the Institute of Chartered Accountants, to have a senior official designated to assist the SIT. This effectively makes it a multidisciplinary investigation with appropriate skills. And in the past, going back to 92, such a committee has delivered good results. Like I said, when it's reported nationwide, it will encourage other affected home buyers to seek legal recourse. There are cases by them pending in high courts across the country. The high courts will take a signal from the Supreme Court order and the proceedings, which also will work in the interest of home buyers. And it may create pressure to include more cases either in the SIT investigation or launch fresh investigation. So I do think that this time things may be different. But what is clear is India's regulatory architecture has struggled to match the scale of malpractice and corruption in real estate. RERA had promised fast-track dispute resolution, conciliation, but implementation has been poor and patchy. People are waiting. Sometimes they're fighting for online hearings and in-person hearings. This is happening even in better governed states. The SC order unequivocally signals that India's regulators have failed to deliver the protection required by home buyers. Hopefully, RBI and the government will respond to this order itself instead of waiting for the SIT investigation to proceed and for the SC to issue further directions to curb the unholy nexus. It's time they take a look at it themselves. Unfortunately, they're up against a wall. Deep-rooted corruption continues to thrive in the real estate business. Bribes are obligatory for building permissions, occupancy certificates, even routine registration of property and rent agreements. None of us can escape it. The price of escaping these bribes is long waits and harassment. Since real estate also attracts humongous political money from our netas, as well as all the corrupt money of babus and government officers, these proceeds of corruption act as a force to shield this industry from reform and to put an end to corruption. Will the Supreme Court cut through this? That is the only way I see things happening. The SIT investigation, if properly conducted, ought to expose the true extent of corruption in realty. In fact, even a cursory look at the spectacular failures in this industry over the last few years highlight the enormity of the problem. Among the large failures you have, and these are well-known names, Unitech, JP Infratech, Amrapali Group, HDIL, Diwan Housing, together the two sides of the Vadhavan family brought down PMC Bank. There are innumerable smaller names which were highly trusted at one time. DS Kulkarni of Pune, ATS Infrastructure, Omax, Radius, DB Realty. One can go on. This is just a smattering. Each of them triggered losses for home buyers, some battles. Sometimes people gave up because there's no money to fight. Long-term change is not going to be easy. It will demand more than court-monitored probes because everyone cannot go to court. It will require regulators to impose capital adequacy norms for developers, enforce milestone-based disbursements, adopt a new policy where you build first and then sell instead of taking bookings the minute you have an idea and a plan ready. This build and then sell model aligns with revenue with delivery. So scope for cheating comes down. Above all, it will require political will to root out entrenched corruption that has allowed powerful players to gamble with people's life savings. The judiciary has struck a match. Hopefully, it will do more, but it is the government that will keep the flame alive only if there is sustained public pressure. So remember, the buck stops at you. We need to pressure the government to ensure that this order is taken to its logical conclusion. If you agree, please share this video and subscribe. Thank you.